This is the biggest case in Colorado right now, and I know you're not about to try to tell me that it was just sitting on your desk like, oh. She took time to clear the Ramseys, and the Ramseys were the ones indicted. But if I hand out an indictment, oh, you caught the killer. But if I don't, y'all don't know the law anyway, so you can't say anything to me. Are you gonna give him more people to help disseminate false information? But everyone else who was not indicted remained under the umbrella of suspicion and had to beg to be taken off that list. Interrupting our regularly scheduled program to show some love to one of the channel's most avid supporters, Pill Poppin' Polly. Show some love to Polly in the comments. Polly, we love you. Appreciate your support. Okay, jumping back in on this, Fleet White's letter to the Fleet and Priscilla White's letter to the district attorney. I want to cut it off to kind of, because this is going to be somewhat lengthy, so I want to give you guys time to digest it and come back. So basically, we left off kind of right here, and we're talking about how, you know, John Ramsey doesn't really question Fleet White a lot. You know, he just kind of lets Fleet say what he's going to say, and then John Ramsey very lightly disagrees and says, well, I mean, Fleet thinks what he thinks, and I don't know why Fleet turned on me, but he did. You know, kind of a soft spot for Fleet right there. You know, Fleet is a little bit younger than John, if I remember correctly, but, you know, John still has like this soft spot for Fleet. And so he's just basically like, dang, man, dude kind of turned his back on me. That one hurt, you know. So anyways, we kind of got here and essentially talking about how Fleet White and Steve Thomas were trying to get these letters out before the possibility of them being subpoenaed by the grand jury came, and it kind of shut them up. If I'm remembering correctly, there was a case with Mary Keenan. It was Linda Hoffman Pugh versus Mary Keenan. I think, and I didn't read the contents of it. Well, I don't remember the contents of it, but essentially, what it was talking about, what the idea of the case was, Linda Hoffman was saying, y'all need to let me talk. Y'all got me under these wraps of this grand jury proceeding. Y'all need to let me talk. I want to talk about what I know. I want to talk about what, you know, basically, can I say, I'm not trying to talk about what I said in the grand jury proceedings. I want to talk about my opinions before that. But she didn't understand that you no longer can talk. You can't talk about before or after. You can't talk about it at all, essentially. So because we can't determine what you knew before is essentially what you know, the grand jury sort of prevents you from doing. It gives you, you're under that sort of cloak or code of secrecy is essentially what you didn't understand. So basically, Fleet White and Steve Thomas know that this is coming. And so they're like, before y'all even get me under this cloak of secrecy stuff, I want to get something out there to the public. I want to get what I know out there to the public before y'all try to stop me. And this is what they put out because they kind of understood or knew, because Fleet White has been busy. Fleet and Priscilla White have been busy. Kudos to them and Steve Thomas for getting out and getting things done, being busy to kind of present. These are former friends of the Ramseys to present and say, look, there's a problem here. Y'all need to appoint special prosecution or independent prosecution to drive this. So anyways, this is why we're having this conversation. So the district attorneys, I think we left off here. The district attorneys passed indecision and the need for police to ask him for a grand jury investigation were deliberate attempts to mislead the public. This is Fleet's point. Look, the fact that the fact that you didn't think that we needed a grand jury to kind of intervene on this case, you knew we were at a standstill and you knew we weren't going anywhere. So the fact that you knew that we needed a grand jury and you didn't put that in there, that's a problem. That don't make no sense. So the district, you had indecision, and so it's deliberate. Not only are you doing it on purpose. If based on nothing other than the district attorney's repeated public statements and leaks characterizing the case as not prosecutable, there can be little doubt that absent a confession, the people running the investigation had long ago decided against filing charges in the case. So basically this right here, this is not me. This is not anybody in the comments. This is not anybody on YouTube. This is Fleet White, these people's friend, the close friend that is coming out and had a blow up at the funeral, at JonBenét's funeral. This is Fleet White. This is Fleet White and Priscilla White coming out and saying, as we listen to the DA, this man is already stating that this case is close to the time period, close to 1996 and into 97 and 98, saying, look, man, this entire time, what we believe as people who have been interviewed and who are close to the investigation and who may possibly be subpoenaed to have to speak or witness before the grand jury, we're saying that this entire time, if based on nothing else, the district attorney has continually made statements and leaked information letting us know that this case is not prosecutable. You don't even have the evidence from the police yet. At this point, you're going out and making public statements and you don't even have the evidence from the police yet. How do you know this case is not prosecutable? What do you have that's letting you know that this case is not prosecutable? Are you trying to condition the public to make us believe that this case that we might as well stop before we get ahead because there's no way that we can prosecute these people? Why would you be saying that? What is there to let you know that this case cannot be prosecuted? 30,000 pages of investigative reports, and you're telling me that nothing in those 30,000 pages is going to lead us to anything? Nothing? That's crazy. No charges? None? No charges? We can, the witnesses themselves are telling you that they tampered with the crime scene. No charges? Okay. Instead, they manipulated the public opinion to favor the use of the grand jury. There is compelling evidence, however, that their motivation for presenting the case to a grand jury has little or nothing to do with obtaining new evidence, grilling reluctant witnesses, or returning an indictment, and everything to do with sealing away facts, circumstances, and evidence gathered in the investigation in a grand jury transcript. So what he's saying is, the grand jury can be used as an investigative tool to kind of go through all of these things and find facts and new evidence and kind of, we're at a standstill. Let's find some new facts and stuff like that. But Fleet White is saying that's not what this is being used for. It's being used because we know that it can be used to shut everyone up and get all of the information. You know what? There's a bunch of theories out here. There's a bunch of stuff out here. Let's get all the key players together and put them in one room. Let's get all of the evidence together and put it in one room. Put it on this transcript. And because of the shroud of secrecy and the code of secrecy that this grand jury has to exist under, and you can't talk, put it all on paper here. Say everything. That's why you can't talk about Burke's high-tech boots. We couldn't do it for a while because we didn't know that existed. Outside of these interviews, we didn't know it existed because it was locked away in these grand jury case files that they can say, okay, it's all here. You can't ask anything about it legally because it's locked up in the grand jury and that's under secrecy. So you can't ask about it. So, and this is what Fleet is saying closer. And I'm not saying it. This is what Fleet White is saying. So it is our firm belief that the district attorney and others intended to use the grand jury and its secrecy in an attempt to protect their careers and also serve the conflicting interests of powerful, influential, and threatening people who have something to hide or protect or simply don't want to be publicly linked to a dreadful murder investigation. Also weighing on the district attorney has been the matter of preserving and protecting the now cooperative and forthcoming Ramseys' rights as victims. The Vanity Fair article said that whether they are prosecuted here in the public eye or in the something to the effect or in court, these people have already lost because, you know, they've lost a little girl and the public is already railing on them. And so these guys have already lost a lot. You know, basically, what more burden do we want to put on these people? You know, I relate this in a sense to Latasha Harlins. And if you don't know Latasha Harlins, the Latasha Harlins case, Latasha Harlins, man, I was listening. I didn't know anything about Latasha Harlins at all. Man, I was listening to a Tupac song and he said, little Natasha so grown, Natasha, I think it's Latasha. Correct me if I'm wrong. But he said, tell the lady in the liquor store that she's forgiven, so come home. And I was like, who is that? And so I went back and I looked at the lyrics of the song and I was like, who's he talking about? So I went back and looked at the lyrics of the song and he was talking about, I got to get this right. I don't want to keep saying her name wrong. Tasha. Yeah, it's Latasha. Latasha Harlins. Yeah, Latasha Harlins. And I went and looked, and essentially what happened was Latasha, she was 12, 13, 14. How old was she? She was 15. Yeah, she was 15. She was 15 and she walked in and she walked into a grocery store, something, if I remember correctly, she walked into a grocery store and she went to get some orange juice. So she got the orange juice and she came up to the front. Now, apparently people have been robbing the store and stuff like that. You know, Latasha has money. She has money in her pocket. And so she walks up. Now, Latasha, she didn't have any issues in school. She's a good student. And so, you know, I don't know. Nobody complains about her, essentially, is from what I read. So she goes to the store, gets, you know, some orange juice. She goes to the counter to pay for it. And I forget what she was doing, but there's some finagling at the counter. And the lady was like, hey, you're trying to steal. You know, you can't be stealing. And so the lady, I forget what she did, but the lady grabbed her backpack. I think she thought she was walking away. And so the lady grabbed her backpack and was like, hey, you're not stealing from me. And Latasha turned around and was like, I'm not trying to steal from you. I got my own money. Who do you think I am? Tasha caught a little bit of attitude. If I'm understanding correctly, correct me if I'm wrong. She caught a little bit of attitude. She's like, I'm not trying to steal from you, man. I got my own money. And I think she took the money and threw the money in the lady's face. It was like, boom, take that. Here's my money if you were looking for the money. And so the lady got mad. And so she picked up, you know, her piece. You know, she picked up her piece, she retrieved her piece, and I think Latasha was walking away. You know, she said, here's your money, boom, boom. You know, here's your money, take it, get out of my face, stop talking to me. And she took her stuff and she was walking away. And as she's walking away, the lady pulls out a piece and boom, you know, catches her in like the back of the head, you know, with her piece. And obviously, you know, unalives Latasha. And so people were on fire because of that. Because I think that was around the time of the Rodney King and all such as that and stuff like that. And so people were livid. But the point that I am making is when this lady went to court, I think she got, he was convicted of some sort of manslaughter or something like that. She was convicted, but the judge jumped in the way and said, well, I understand what the jury said. But I don't think you're a bad person. I don't think it would be, you know, it'd make any sense to put you, because I don't think you're going to continue to do this. I don't think it would make any sense to, you know, put you in prison over this. And people were furious because it's like, what's the justice system for? I didn't ask you what you thought of this person. I'm telling you that this is the penalty for this person doing this, right? Because a lot of people who probably would never, you know, unalive somebody again are behind bars because you got to pay the consequences. And so you jumping up and saying, oh, no, absolutely not, becomes a problem. Right. And so this kind of sounds like Alex Hunter saying, well, I don't want to do it because these people have already suffered enough. Alex, I don't remember asking you anything about what you thought. I'm just asking you to do your job and prosecute. I'm not asking you, oh, man, I don't want to waste taxpayers' money. Please waste it as a nation, not just in Colorado. I'm pretty sure if they had GoFundMe at the time, GoFundMe would have been like, hey, please, we'll reimburse the charges. Anything will reimburse the state's money. Just move forward with bruh. Let me move forward before I work myself up again. Also weighing on the district attorney has been preserving the Ramseys' rights as victims. In direct response to Mr. Thomas's recent letter, Governor Romer met on August 12th of 1998 with District Attorney Grant, Ritter, Peters, and Thomas. Later that day, Governor Romer announced at a press conference that Hunter had told him that the case was on track for a grand jury. Romer said that it would be improper to appoint a special prosecutor now, even though we asked you like 8 months ago to do this. Now you're just now getting around to it. This is the biggest case in Colorado right now. And I know you're not about to try to tell me that it was just sitting on your desk like, oh man, this is just, it's just sitting on my desk. And I just haven't really got around to it. This is the biggest case in Colorado right now. And you're just now getting around to tell me, well, we, it wouldn't be proper to appoint a special prosecutor right now because you waited 9 months, bro. Appoint the prosecutor. Stop waiting. That's what people are mad at you about. You wait and wait and wait, and then you come up with, I can't do it because there's no way that we. This is more of that nonsense that you're doing. See that nonsense the legal stuff. You see what I'm saying? The little legal stuff and this is what I'm saying in response to this other gentleman who was saying, oh, you don't seem to know much about the legal process. We know you're playing games. That's what we do know. We know that you're waiting and stalling. And this is not just me. This is people close. This is Fleet White. Tell it to Fleet White. Tell Fleet White he don't know much about the legal process. Please absolutely go ahead. This man right here close to the case being questioned is saying, man, bro, I mean, this is why he was mad at John Ramsey. This right here is why he was upset. Because this stalling, he was saying, why is it taking you so long to talk to the cops? Just talk to them. You're stalling. I don't like that. That's what we're talking about. Legal process or not. When you say stuff like that, it sounds like you're trying to play this legal game of not really trying to find justice. It more so sounds like you're trying to play this. The art of arguing is what it becomes, is what you're really trying to do. Who can argue and philosophize better? Which is what some attorneys devolve into. No disrespect to attorneys. I'm not saying, I'm just saying sometimes attorneys devolve into, sometimes people in general, well, a lot of times people in general, just human behavior, devolve into this game of arguing to be arguing. Like we're not even talking about anything. We're just arguing to be arguing. And once somebody stops and says, what are we even talking about? I don't know. I was just arguing because you were arguing. Not doing that nonsense. Stop talking to me about that. Robert says it would be improper to do so, but that to improve public confidence in the case, he would make available to Hunter additional prosecutorial expertise. Sure. Governor Romer, I don't know how stupid you think we are, but if you keep the same man in charge, but with more people, we've already talked about how he's disseminating information in leaking. Are you going to give him more people to help disseminate false information? You going to give him more people all right. Now I have more people to help me delay this process. That's all you're doing. You didn't do anything. You didn't. You just added more people to his team. It's the same dirty swamp. You didn't. All right. It's getting stupid, man. So I'm gonna give him more people to be ignorant with. So shortly after the press conference, Hunter's office announced that the case would be presented to a grand jury in order to gain additional evidence in the case on August 13th of 98. All of a sudden, the ball is rolling. On August 13th of 1998, the Rocky Mountain News offered an editorial entitled Calling in the Cavalry, in which the editor generally supported Governor Romer's action, but insightfully asked the obvious question, why has it taken so long for Hunter's office to present the case to a grand jury? The editorial read, this is a question that somebody close to the case is asking, why is it taking y'all so long to get the grand jury? I mean, I support you. I respect you. I'm with you, but why is it taking you so long to get this case rolling. Oh my God, why are you putting this on the governor? The governor is doing everything that he can. Absolutely. I'm just asking about your boy. Why is it taking your boy so long to get the grand jury up? It says, but if the Ramsey case is on track for a grand jury, as Romer insists, it seems to have been sitting on a siding for quite a long time, awaiting clearance to proceed. So if it's on track now, this is what the editorial is saying. If it's on track right now, it seems like it's been sitting there for a long time, just waiting to be cleared. It's not that it wasn't ready. It's not that it couldn't proceed. It was just waiting for your clearance to proceed, meaning it's been sitting there the entire time. This is all the more true given the fact that Ritter, Grant, Thomas, and Peters obviously believe that the grand jury must be used as an investigative tool in the Ramsey case and not merely to reach a predetermined prosecutorial goal. If that is the case, why wasn't a grand jury used months ago? Indeed, why wasn't it used more than a year ago? If this is truly a prosecutorial tool that could have helped us in the investigation, why did we not use it from the get-go? If we were having these problems a year ago, why didn't we just go ahead and use go ahead and put in and implement and instill the grand jury? Why didn't we do that a year ago if we wanted to find new evidence? Because this has been sitting here at least a year. We have been at a standstill for at least a year. And y'all sit here and waited. This is not me, Armchair Detective Cato. This is not me saying this. This is people close to the case saying this could have been done a year ago. Following the Sid Wells murder in Boulder in August of 1983, a grand jury investigating the high-profile case met off and on for about 15 months without returning an indictment. Quoted in the January 29, 1984 Denver Post, Boulder Assistant District Attorney Bill Wise revealed that the case had been originally referred to the grand jury because of its power to further investigate. That means we're using it as an investigative tool to get more information on the case. That we're at a standstill. So this was referred to, the grand jury was referred so we can get more information. The district attorney didn't have a subpoena power, and we needed that tool. So the district attorney didn't have subpoena power, so we needed that tool, the grand jury, to further investigate. Hunter had waited less than 3 months before presenting the Wells murder case to a grand jury. He waited less than 3 months. 3 months after the death of JonBenét Ramsey, police were still trying to interview John and Patsy Ramsey and obtain other evidence critical to the case. This is funny because this line is funny because if you go back and you look at the Larry King interview where you had Steve Thomas and you had the Ramseys and you had Patsy Ramsey and they were arguing back and forth, Steve Thomas poked at the Ramseys and said, man, it took y'all 4 months to come in. And John was like, no, it didn't. We were there the next day and we were there with this and that. We were doing this and that and blah, 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 blah. So this is the second person coming in and saying, bro, it took y'all 3 or 4 months to come in. Y'all didn't come in immediately like you said you did. You're coming in and my coming in are different. I came in to try to whatever you needed. I'm here. I'm witnessing. I'm talking. I'm doing whatever. Y'all didn't come in for 3 months. Legitimately come in, not coming under some nonsense. Y'all didn't come in for 3 months. This is the second person. This is not me saying it. This is Flea and Priscilla White. There's a relatively simple but compelling answer to the question raised by the Rocky Mountain News editorial. Since very early in the case, there has been at least a tacit understanding among the district attorney, police leadership, those persons advising these agencies, and Ramsey defense attorneys that the case would be presented to a grand jury, but not until the statutory Boulder grand jury was convened in April of 1998. This delay was deemed necessary by some or all of these parties in order to take advantage of the new statute 16-5-205.5 CRS concerning the grand jury reporting procedures, which was the result of legislation promoted by the Colorado District Attorney's Council and passed by the legislature in early March of 1997. This new statute that was being pushed for the grand jury concerning grand jury reporting procedures, which was the result of the Colorado District Attorney's Council. I have to think that this had something to do with DA Hunter and passed by the legislature in early March of 97. By law, however, this change in procedure would only apply to reports issued by grand juries convened after October 1st of 1997. In order to take advantage of the new statute, a Boulder grand jury would have to wait until April of 1998, the next convening of the statutory Boulder grand jury subsequent to October 1st of 1997. In order to accomplish this, it was necessary for these people to stall and cynically rely on the public's relative ignorance of the statute and the purpose and general nature of grand juries. The district attorney and the police leadership worked hard to create the fiction that the police investigation was not complete and therefore not ready to be transferred to the district attorney. So as long as the district attorney didn't have the case, it would be difficult to fault him for not prosecuting or presenting the case to a grand jury. It was this fiction that was used by the district attorney to deflect mounting criticism. There's that word deflect, as we've been saying, deflect, deny, all of that. Mounting criticism, including that contained in our letter in January of 1998. It also served as the basis for a Boulder court to throw out a suit brought against the district attorney by New York attorney Darnay Hoffman, who had accused the district attorney of constructively abandoning the case. The district attorneys publicly expressed indecision in late 1997 regarding a grand jury investigation, gave way to his progressively greater leaning towards such a decision as the date for convening the Boulder grand jury drew near. Oh, there it is. House Bill 97-1009 was drafted. There it is. Ha ha ha. Da-da-da-da-da-da. TCL 1997 Criminal Legislation, September 1997 Criminal Law Newsletter, The Colorado Lawyer, September 1997, Volume 26, Number 9, page 79, 1997, The Colorado Lawyer and Colorado Bar Association, all rights reserved. I ran across this. And all I have to do is type in grand jury. There it is. HB 97-1009. This act creates a mechanism for grand jury reports to be made public when there is no indictment. This act creates a mechanism for grand jury reports to be made public when there is no indictment. If the court is satisfied that the report meets certain statutory criteria and is in the public interest, the report can be released to the public. So this case entirely is the public interest. It has to be there because there's a lot of public interest on this case. There is a mechanism for persons discussed in the report to file comments. To be in the public interest, the report must make allegations of public malfeasance or commission of class 1, 2, or 3 felony. This act is effective for reports submitted by grand juries on or after October 1 of 1997. So when we look at class 1 felonies, class 2, class 3. Class 1 felonies are the most serious, followed by class 2 felonies and class 3 felonies. The exact classification of a crime varies by state. Class 1 felonies, capital murder, first-degree murder, and crimes that involve violence or the threat of violence or death. Class 2 is felonies, arson, kidnapping, aggravated malicious wounding, murder, and burglary with a deadly weapon. Class 3 felonies, shooting or stabbing a person, attempting to poison someone, certain drug crimes. So, a commission of these three. This act is effective for reports submitted to grand juries after October 1, 1997. Colorado Revised Statutes, Title 16, Criminal Proceedings. Number 1, in any case in which the grand jury does not return an indictment, the grand jury may prepare or ask to be prepared a report of its findings if the grand jury determines that preparation and release of a report would be in the public interest. And so basically the grand jury would say, if we don't return an indictment, then we can ask for a report to say this is what we've done. Because if the public's going to be like, well, what did you find? Well, what, like we're asking, what did you see? Like, what did you get? And they were going to say, we don't have to answer you. We can just give you a report and let you all see it. Public's interest. As described in subsection 5 of this section, the determination to prepare and release a report pursuant to this section must be made by an affirmative vote of at least the number of jurors, like 12, I think, that would have been required to return an indictment. Okay, well, maybe not 12. The report shall be accompanied by a certification that the grand jury has determined that release of a report is in the public interest as described in subsection 5. Number 2, the provision of this section shall not apply in any instance in which the prosecuting attorney chooses to file charges against the person or business that was the subject of the grand jury. The provision of this section shall not apply if the DA chooses to file charges. If you choose to go and file charges, then we can't release this report or business subject to this investigation. Within 14 days after receiving a report of the grand jury prepared pursuant to subsection 1 of this section, prosecuting attorney shall notify in writing all persons business, blah, 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 blah. Okay, you have to come if you do. Upon completion of the time for submitting responses, blah, 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 blah. I don't think this has anything to do with it. Blah, blah, da, da, da. Releases grand jury report pursuant to the section may be deemed to be in public interest only if the report addresses one or more of the following: allegation of the misuse or misapplication of public funds, allegations of abuse of authority by a public servant as defined in this section, or a peace officer as described in this section, alleged allegations of malfeasance or malfeasance with regard to government function as defined in this section, or allegations of commission. Okay, so it's probably best in public interest if it's one of these, and we know it is. And so this is important basically because of this. And had people known, this is very new, so people would know. This is very new. This would have been very new at the time, so people wouldn't have known. So what Fleet is saying is that, what Fleet and Priscilla are saying is that, as they write this up, is that let me get to the point. In any case in which a grand jury does not return an indictment, we have to we can ask for a report to be prepared in the interest of the public if there is no indictment returned. But as you know, there were indictments returned. It was called a true bill. It's called a true bill if there's going to be an indictment, and I think it's a non-true bill or not a true bill if there are no indictments. So, anyways, this is what they're charging them with, right? And so, had people been aware of the law, they could have read factually in at the time and known that based on the fact that we could not get a report and that Alex Hunter was able to seal it up and say, don't ask me any more questions, we could have known based on that fact that there's an indictment. There was an indictment, because if there wasn't, then we could have legally asked for a report. And the jurors would have given us one, because they probably don't want to answer questions. Right. So that's what this is saying. And that's what essentially Priscilla and Fleet are saying when they bring these things up is, Alex, you knew that an indictment would stop the trigger of a report. And so all of that stuff that we talked about would have been laid bare in front of the entire public if an indictment wouldn't have been triggered. But since an indictment was, then you didn't have to tell us what happened, and you can close it up and you can say with confidence, I don't got to tell y'all nothing. According to grand jury proceeding, whatever. House Bill 97-1009 was drafted by Colorado District Attorney's Council in late 1996 and was introduced to the Colorado House of Representatives on January 8th of 97, 2 weeks after JonBenét was killed. HB 97 1009 was sponsored by Representative Bill Cobman, a Republican, and Senator Ed Perlmutter, a Democrat. The impetus for this bill was the desire of the council to take effect legislation changing an existing statute 165205 for CRS regarding the issuance of grand jury reports in those cases. Ooh, Fleet is thorough. Oh, I love this. They are thorough. This is beautiful. They are thorough. I'm going to tell you what they're putting in place, but I'm going to tell you what it's replacing. Oh, I appreciate you. I appreciate you, Fleet. And Priscilla. So this is changing the existing statute regarding the issuance of grand jury reports in those cases where there is not an indictment. The matter was discussed by the district attorneys and legislators at a conference in the summer of '96. So we had already talked about this, didn't even know this was going to appeal to or happen with JonBenét, but we had already talked about this. It's just whether or not we want to push it. The existing statute allowed the issuance of reports, but was argued to be confusing and overly restrictive. As a result, grand jury reports were non-existent. In a January 19th, 1997, oh, I see. So prior to, there was confusion about whether grand juries could give reports or not. And so because, you know, it was confusing and what was allowed was just restrictive, then they just didn't do it at all. They just said, all right, this is what we've done. It's never going to come out. And so people got in and argued and said, man, that's too restrictive. We need to understand what's going on. But in order to understand what's going on, DA Hunter needs to understand the implications of this new bill coming out. So I have to wait to study the implications. And that's why you would drag your feet. If we are going to bring to bear a grand jury, I have to drag my feet long enough for this thing to not only pass, but I need to understand the implications of this so that if somebody says, hey, these things are restricted because this is going in the public eye, I gotta have something for the public. And so if I'm gonna bring something to the public, I first need to understand what I'm presenting in full so that I can bring clarity and I can understand what my role is in this new legislation. As a result, anyways, in January 19th of 97, editorial supporting passage of the bill, the Denver Post pointed to the inconclusive grand jury investigations concerning DIA and police conduct in high-profile occurrent case in Arapahoe County. Arapahoe County. Also mentioned was the recent Trofax, I don't know how to say that name, officer involved shooting case in which Denver DA Bill Ritter chose not to use a grand jury to investigate possible police officer misconduct because of his concern that the grand jury might not report its findings to the public. So Bill Ritter chose not to use a grand jury to investigate the police officer misconduct because he was concerned that the grand jury might not report its findings to the public. Citing these cases, the Post urged that in the balance between the public's right to information and the statutory demand for grand jury secrecy, public disclosure should carry more weight than it now does, the Post editorial went on to say. So basically, what's happening here is you're getting a lot of pressure from the public for transparency is what's happening. And you can't just, because what's going to happen, you can't ignore it, because if you want to stay in office, you can't ignore it. You have to do something about it because the people are calling and saying, we want more transparency. And Bill Ritter is here. He's like, oh man, you know, I don't want to use the grand jury because if I use the grand jury, then it's going to close it up in secrecy and there's not going to be anything I can do about it. I might come under fire because people are going to be like, well, you did that on purpose so you could hide what the police misconduct. And so he was like, man, well, I might not want to use that because I don't want to hide police misconduct. I want it to be open to the public. And so that was a smart move. I would say that was a smart move if he wanted to avoid that. So the Post editorial went on to say, the proposed law would instruct judges to determine whether the report should be released and allow for withholding any parts necessary to protect witnesses. It would also give witnesses an opportunity to see reports and file opposing motions if they object to their release. Such reports could go a long way toward dispelling doubts like those that still linger over the DIA and TRUAW investigation, or TRUAX. TRUAW, I think I'm thinking I think this is Cajun in some way. True. Maybe it's true. True. Anyways, investigations, and by providing all witnesses with safeguards against disclosures that might damage or embarrass them. Still preserve the confidentiality that is both the armor and the engine of the grand jury process. So we don't want to compromise the grand jury process. We still want to have the secrecy and the safeguards to preserve the confidentiality of the witnesses and everything, and not embarrass people or damage people's credibilities and character and stuff like that. We still want that to remain. But we also want to have a little bit of the element to where there is transparency, to where you are legally responsible to talk to people. You can't just be like, you guys aren't lawyers, shut up, you don't know what you're talking about. And that's what I'm saying. Again, going back to the fact that you shouldn't have to be a lawyer to be able to get in on this process is essentially what people are saying. I shouldn't have to understand intricately or in great detail the ins and outs of the legal field in order for me to be able to jump in on this case and say this is right or wrong. Right. And the public it's important to understand what the public is doing or what the public wants and stuff like that, because the public is electing the officials. And if you cannot represent us properly, we're telling you we need more transparency because they're asking for more transparency, we will get you out of here. And if you can't give us more transparency, because look, there have been cases that have come through here, and in DA Hunter, we think that you're being shady. And any of you other guys that we think are being shady, because we're trying to get information, because sometimes these are people's loved ones that are going to the grand jury and stuff like that. And these things are going to the grand jury. And when I'm asking as a family member about what happened to my friends or my family, you're telling us we can't tell you that because because of what? Because that's locked under some grand jury proceeding. And people, if you're not legal minded, or you don't value that to that degree, to that extent, that's not going to work. People are going to eventually become erratic. They're going to become frustrated, and they're going to sort of exhibit some sense of anarchy, I might say, because they're like, yo, you're trying to stop me you're trying to use all this legal language to trick me. And that's why and it's going to get a little feisty. That's where you get the riots and the protests and stuff like that, because people feel like you're treating them like they're stupid. And eventually somebody going to do something crazy. I'm not condoning that. I'm just saying, with the way people's minds work, somebody is eventually going to do something crazy, and it's going to be extreme. And so to prevent that sort of extremeness or extremism, we got to go ahead and change it, which is what you're supposed to be doing anyway. If you're serving the people, this is what you're supposed to be doing anyway. The original draft of the bill was presented to the House Judiciary Committee by Representative Kaufman at a hearing on January 21st of 1997, long after the Ramsey case had exploded into a national news story amid growing suspicions of police mishandling of the case. Speaking in favor of the bill before the committee were District Attorneys Ritter, Thomas, and Grant. All of these district attorneys, along with Jim Peters, would be named publicly as advisors to Alex Hunter on the Ramsey case a few weeks later, on February 14th of 1997. It is clear from the draft bill and from their comments at this hearing that they intended reporting by grand juries to be on matters generally limited to allegations of non-criminal misconduct by public employees, officials, and agencies, but only when such information regarding those allegations was in public interest. At the hearing, Mr. Ritter stated, there are other matters where we bring an issue into the grand jury for investigation and it grows legs, and we find ourselves investigating the conduct of government officers, the conduct of public employees, the conduct of government programs where, because tax dollars are involved, the public does have a right to know something about the operation, even if they fall short of the conduct being criminal. And that, I think, is the real meaning behind a bill like this. So basically, up until this point, and this is what I was thinking, right? If something is legitimately important, well, we're finding stuff that, like, you need to explain to us, it can grow legs. That's what I'm saying. This thing can grow legs and it can take on a life of its own, and we need to investigate that. And people have a right to know the result of this investigation is what is happening. And so when we think about this in relation to DA Hunter and his office, they would have to have time to study this. They would have to have time to study this and say, okay, again, how does this apply to what we have to do and what are our responsibilities in this case? What do we have to tell the public? Because we are responsible to the public. The tax dollars are involved. We have to respond to the public in some way. And that's how you start to formulate your opinions. And that's how you start to formulate your plan and your strategy. I think this is the real meaning behind a bill like this. Also speaking in favor of the bill were John Daly, head of the Criminal Enforcement Unit of the Attorney General's Office, and Kim Moores of the Colorado Judicial Department, appearing at the request of the Chief Justice of the Colorado Supreme Court. Also speaking in favor of the bill was Marge Easton of the Colorado Press Association. On March 5 of 1997, Senator, and this is the Democrat, Perlmutter, presented the bill to the Senate Judiciary Committee. Appearing once again to speak in favor of the bill were Bill Ritter, Marge Easton, and John Daly. Also speaking for the bill were Ray Slaughter and Stu Van Meveren of the Colorado District Attorney's Council. The final bill was passed on March 21 of 1997. Included in the bill were specific criteria to be used by grand juries and prosecutors in determining what constitute public interest. And we read through these for the purpose of the grand jury report. And we read kind of through these 1, 2, 3, and 4. We said that this would probably be where it falls. So kind of continuing on, the original intent of the Colorado District Attorney Council draft and that of Representative Kaufman was to make it easier for grand juries to issue reports in cases where there is not an indictment returned, but where, in the public interest, the grand jury wishes to address allegations of misconduct by public employees falling short of criminal conduct. The final bill made it possible for a grand jury to address allegations of first and second degree murder and the classes of child abuse resulting in death. Huh. 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 Well, there it is. That's why you have had to make it public. The final bill made it possible for a grand jury to address allegations of first and second degree murder and 2 classes of child abuse resulting in death. The new statute would enable a Boulder grand jury to investigate the death of JonBenét Ramsey to publicly exonerate someone who has been alleged to have committed one of these crimes, but only in the event an indictment was not returned. The bill was signed into law by Governor Romer on April 8 of 1997. We strongly urge those wishing to investigate the intentions and motives of the Colorado District Attorney's Council, legislators, and those speaking on behalf of the bill to review the Senate and House journals and listen to the tapes of the House and Senate judiciary hearings and floor debates on file at the Colorado State Archives, 1313 Sherman Street, room 1B20 in Denver. The new statute would enable a Boulder grand jury to investigate the death of JonBenét Ramsey to publicly exonerate someone who has been alleged to have committed one of these crimes but only in the event an indictment was not returned. This allows me to investigate, or the grand jury to investigate, the death of JonBenét Ramsey, to publicly exonerate someone who's been alleged to have done this, only if the indictment was not returned. Are you saying that if we wouldn't have returned an indictment, and this is where legal language gets complex, are you saying that if we wouldn't have returned an indictment, if we would have said no true bill, and if we wouldn't have returned or said that the Ramseys did this, which is an indictment, if we wouldn't have said that the Ramseys did this, then we would have been allowed to investigate further into the JonBenét Ramsey's death, to publicly exonerate someone who's been alleged of committing these crimes. So are you saying that it's possible, if we would have said, okay, whatever the crime, not even child abuse, first or second degree murder, in the two classes, any one of those things, the grand jury could investigate and publicly exonerate anyone, Linda Hoffman, Fleet White, Priscilla, the Steins, anyone, Carr, Oliva, anyone. They could have come out and they would have had more work to do. If they wouldn't have returned an indictment, they would have had more work to do. And if they would have had more work to do, then they could have went on and publicly exonerated and said, you know what, we are publicly, as the grand jury, exonerating the whites. We are publicly jumping out here and we're saying Gary O didn't do it. We're publicly coming out and saying that John Mark Carr didn't do it. We're publicly coming out and we're saying that Mervyn didn't do it, Linda Hoffman didn't do it, Grandpa Bill didn't do it. None of these people over here did it. We could publicly continue to investigate and say that, you know, these people have not done it. All of the Jim Marino, Jeff Merrick, all of these people, we could come out and say that, you know, they didn't do it. This would be why after the case, when we watch, you remember we watched, when we watched Fleet and Priscilla White go before the Boulder Council, they went before the Boulder Council and they said, you got to release something that's going to exonerate us. You can't, but we can't talk about this. You got to, and they were like, man, you got to allow us to talk. And we can't release because this, that, and third, and because, you know, it's still under, and the guy was, and I think one of the guy was like a legal expert or something like that. He was an attorney. He was like, oh, you know, we can't because, you know, there's, you know, it's still under investigation. If D.A. Hunter knew the implications of this, it would keep everyone under the umbrella of suspicion, not just the Ramseys. I do two things when I come back with this. If I'm using this bill to my advantage, I do two things. The first thing I do is I come into the public and I say, we can't give you a report because this law says so. Most people aren't going to know where to look, right? They're not going to know to look for this stuff. But Alex Hunter comes and says, betting on your ignorance, and says, okay, I can't do it. That's the law. I can't talk to you about anything. You can't get a report. We don't. And all he says is, we don't have enough to push forward. You remember, and before I move forward, do you remember when we were talking about breaking down certain business terminology, when we're talking about how some things in the financial reports and the financial records, you can hide your misconduct. You can inflate sales numbers. You could say, oh, we sold this money. Sometimes you can inflate sales numbers by saying that, oh, we're looking to sell some things that are receivables that you don't even have yet. You know what I mean? You can inflate that and say, oh, well, you know what I'm saying? That's money that we're coming in. And when people go and break down, and you can report that as part of your sales to drive up your sales numbers. And when people come in and look at the reports and say, but this is not all the money that you made. Some of this money, half of this money is tied up in receivables. You're reporting this stuff, but half of this money is tied up in receivables. And you got to make a note in here in the report. Some of this money is tied up in receivables. And that's why people look at the 10K. Some of this money is tied up in, or half of this money is tied up in receivables. And that means that you might be legitimately, as a company, in a much more disadvantaged financial position than you're actually letting on to investors. But what you'll say is, oh, we've made this much money, and you'll hide the fact that you have money tied up in receivables, meaning that, people are supposed to pay us. We have some IOUs out there and people are supposed to pay us, but they haven't paid us yet. We have a net 30. That means they should pay us in 30 days, but they haven't paid us yet. Those people could decide not to pay you. Those people could decide that, I don't want to pay you. Those people could file for bankruptcy and be like, you're screwed. And you would have to write that off as a bad debt expense. And so all of those receivables that you just reported to people that you didn't know whether you were going to get those or not, investors invested in you when you reported your earnings per share. And those numbers were higher and they beat expectations. And so your stock popped. And so the value of your company popped up to the positive for a gain. Investors come back and they say, wait a minute. You actually didn't have all money on hand that you said you did. But you misled us by saying that, or making us think that, this stuff was on hand when it wasn't. Someone with a better understanding of how to dig through those would be like, wait a minute, they're trying to trick us. And they would get on the earnings call and start to ask questions and say, well, what about this? What about this? What about the receivables? When do you expect to get those receivables? How often do you get those receivables? Because I see you have you have outstanding bad debt expenses of this, and this, and you have a high amount of bad debt expense, more than the industry average. So it doesn't look like, I know you're saying these receivables are there, but it doesn't look like you're really going to get this money. Let me give you let me go further with that example before I close it down. What that might look like is if you're a JCPenney's or something like that, and you're giving a bunch of people the ability to buy on credit, and you're just giving anybody the opportunity to buy on credit. Well, people might take the credit, take the clothes, and never pay the bill, and that credit goes to a debt collector or something like that, or it didn't even go to a debt collector. Maybe it does, maybe it doesn't, and the debt collector is the one calling you saying, "Hey, we need the money." And what companies do is they sell that credit account to a debt collector, and the debt collector says, "Okay, well, we'll take charge over trying to collect this money," and stuff like that is essentially what happens. And JCPenney would take the money that they could basically say, we'll take all the money that we can get, but it ain't going to be that. You see what I'm saying? So how that relates to this here is that if DA Hunter knew everything that was packed in and they took the time to analyze, they could mislead by, number one, saying, hey, look, according to this legal statute, we don't have enough to press forward. I didn't say there was no indictments. I just said I don't think we have enough to press forward. And he would know because he would have been involved in the proceedings thus far. He would have known or understood or been briefed on the proceedings thus far to say, we don't have enough information and I'm gonna get into that later, why he would have known that a little bit more. We don't have enough information to move forward. And that's what he would have been able to get away and say. That's number one. Number two, but if we had known, we would have said, oh, there's an indictment. But most people didn't know, said the public believed in the majority, and what Fleet White was trying to warn us, Fleet and Priscilla were trying to warn us, like, hey, they're going to try to hit you with the okey doke. They're going to try to tell you that, we can't talk, but they're going to try to hit you with the okey doke and say, oh, these people are innocent, and they're not. There's an indictment, but under the thing, he doesn't have to disclose to you that there's an indictment. Just say, we don't have enough to move forward. I'm not signing this. It's simply, I'm not signing that. Number two, I report to the public. I get you off my back, and I say the grand jury, and I make you think that the grand jury didn't have enough. The second thing I do is that I get the indictment, and the indictment essentially closes. If I'm understanding this correctly, the indictment essentially closes the opportunity for us to go out and clear everybody from suspicion. Because if we did not indict, then we're not saying it was the Ramseys, but we also have the opportunity to continue to investigate. And so if we're investigating, then we could come up on the fact that we could say, it's not the whites, it's not these people. So no matter what, stop talking to me about these people. And that would be the job of where Mary Lacey would come in later and clear the Ramseys. She took time to clear the Ramseys, and the Ramseys were the ones indicted. But everyone else who was not indicted remained under the umbrella of suspicion and had to beg to be taken off that list. That's backwards. How is it that the ones who are indicted are the first ones to be exonerated, but the ones who didn't receive any indictment have to beg for you to clear me? That doesn't make sense. I mean, bro, the games being played. So you protect the Ramseys in a couple of ways, like we just said. You close it down and you lead the public to believe that you're doing your job, and the job didn't facilitate it. So we think that the Ramseys are innocent, and we can't say anything else, but we can't also prove that they're innocent. And so we have to just trust your word for it. Trust me, I'm an expert. But also too, you stop other people from being exonerated. During the Senate Judiciary hearing on March 5th of 1997, and after the bill had been amended to include the criteria defining the public interest, Senator Perlmutter stated that he had contacted several defense attorneys I know in Denver, and they were all supportive of the bill. They thought it was a good idea. According to the records at the Secretary of State's office, Senator Perlmutter received a 1994 campaign contribution. Senator Perlmutter received calls that said this is a great idea. Several defense attorneys called and said, this is a great idea. And his campaign had received a contribution from Hal Hatton, defense attorney for John Ramsey. The Hatton firm is well known for its expertise in grand jury practice. Norman Mueller, a partner of the firm, once wrote in April of 1988, an issue of the Colorado Lawyer, defense counsel must creatively and vigorously scrutinize the grand jury process at the earliest possible stage of the case. Oh, yeah. I mean, you're just walking right into it. I mean, I'm not trying to. But let me tell you something. When you understand human behavior, I already know where you're going. I already understood where you were going because it has to happen. I have to get what I want. We can tell you that Hal Haddon is going to make this contribution. I already, if because I need, if it's like the mafia, I need to have an inside person. This guy is a Democrat. So therefore, he and I we're going to get along just fine. I'm going to make a contribution to your campaign. And if I know that you are working on a grand jury process, let me tell you how this works in case you don't understand how this works. If you are in academia, and a lot of the research that you do is there to drive policy recommendations. So a lot of times when you write, you're going to go do your research, and you're going to go to the Fed. You're going to go to whatever agency that you're interested in doing research for, and you're going to say, "Hey, here's my research on why we should pay attention to climate change. And these are the policies that I think should be instituted." It happens in the same way in school. The school's going to go out and they're going to go talk to some what do you call them? Not advisors, consultants. They're going to go talk to some businesses, do the same thing. They're going to go talk to consultants and say, how many people should we lay off to keep this company lean and making money and sort of efficient and effective and positioned well for the future. They're going to go into schools. They're going to be like, what do we need to do? What curriculum do we need to implement to make sure that we get the best scores, or whatever we need to do? We can save the school district money, but we can get the best outcome, and we can drive up scores and stuff like that. And whatever recommendation, the person's going to go do some research and say, okay, they're going to present and say, based on this research that we found, this is what you should implement. And then people say, sounds good to me, and they implement it. So Haddon is going to pay Perlmutter to say, okay, we are concerned about the entire process. We want to have a successful practice. And in order to have a successful practice, we need to understand more about the different aspects of the legal landscape and the ramifications of certain things. And in order to understand that, we need to know much more about what the judge is going to do, typically have a general idea about what the judge is going to do. So what do we need to do with that? We need to talk to a lot of judges, and we need to have we need to, first of all, watch what the judges have done with the case law. And we need to understand, we need to talk to a lot of judges. We need to make friends, not only talk to judges to understand what they're going to do in general, but we need to be friends with a lot of judges to understand typically the mindset of the judge. Secondly, we need to understand, okay, what's the opposing attorneys going to do? What is the DA going to do? And what is the jury going to do? And not only what are they going to do, what can they do? How can we get into that process to understand it? So therefore, guess what? If you want to be able to stop something, you're going to jump in and say, okay, we want to maneuver ourselves in to understand more about what certain things, and that's why there's lobbyists, to understand more things about the grand jury process or any part of the legal process. We need to understand any and everything about the grand jury process. And as she's saying right here, we could have predicted this already. Norman Mueller, partner of the firm, somebody that's in the firm way back as far as 1988, said we need to be able to scrutinize the process as soon as possible. That's what I'm saying. We already knew that was going to happen because that's human behavior. I can already tell. You want a successful firm and you want to be able to tell your clients. That's why John would go over there. John, as a Republican, would go over to a Democrat and say, hey, do you know much about this process? And they can say, give me all your money and I can pretty much guarantee you, I know people here, and we can kind of maneuver. We have techniques and we have people on the inside that we can talk to and we can get the information. We have these little techniques and these little tips and tricks that we can kind of sneak in. It can help us give it, because why? What do men need? Men need information to make decisions. We need more data to make decisions. And if I'm sitting in the dark, guess what? I can't make an educated decision and I can't guarantee outcomes for my clients. If I can better guarantee or better guess or better speculate with a high percentage what somebody's going to do or what people have against us, or I know the law well enough to be able to sort of position and say, okay, if this law is this and I know what you're going to do, or I know the evidence that you have, then I know the legal part. All I have to go do is go to LexisNexis and say, okay, this person is saying this. What case law goes against this, or what case law might be opposite, or what case law can we use to defend against this? Can't argue that it's illegal, because I can say this is merely a point of philosophical difference. I'm just finding cases to where the case law shows. I mean, when you say what you're going to say, and I already know every single case that you're going to say, I already know every single case that you're going to present in favor of your position, and I can come back and say, well, according to this case law, this, but there was a case law that said this, and and I can cherry pick, I can take bits and pieces of the different case law in order to get what I want. The May 6th, 1998 issue of the Colorado Journal, a publication for the legal community, presented an article flattering to Alex Hunter entitled "DA Winks at This One with or Without a Grand Jury Indictment. Boulder's Prosecutor Will Still Shine." The article is written around comments received from Senator Perlmutter and District Attorney Bill Ritter. It reads, if Hunter does take the matter to the grand jury and... What was this? May of 1998. So he could be talking about this JonBenét Ramsey case. If Hunter does take the matter to the grand jury and the panel manages to wrestle the evidence it needs to hand down an actual indictment, Hunter will appear the hero for going that route. But if they fail to do so, Hunter could still come out smelling like a rose with the help of a little known state law that went into effect last fall. The grand jury reports may be released to the public if no indictment results in his probe. I wasn't knowing to this. Fleet White was already. Priscilla already saw this. This isn't me. This is Fleet White. Already saw this. They already saw what you were doing. If I hand out an indictment that brings them to bear, then guess what? I'm a hero. Oh, you caught the killer. But if I don't, y'all don't know the law anyway. So you can't say anything to me and I can hide behind it. That way, a prosecutor facing pressure to file charges can say, see, even the grand jury can't find anything. And wouldn't you know it? That's exactly what he said. The grand jury can't find anything. That's exactly what he said. How could anybody have predicted this? Said Senator Ed I think that's Perlmutter, Democrat D. Golden, who co-sponsored the law in the 1997 Colorado legislature. The law, which only applies to class 1, 2, or 3 felony cases, was intended to help the public ease the public's mind in certain investigations where a prosecutor fails to file charges despite pressure from the police to do so, as in the JonBenét case, he said. So you're aware. So this goes outside of just the Ramseys and their attorneys. This goes all the way up the chain. So now we know we got a senator involved. We know we got a governor involved. And not only are they looking, but they're looking intently and they're analyzing the deep interests of the case, the deep effects of the case. They're heavily involved in the case. In the article, Senator Perlmutter indicated that he sponsored the bill because he didn't want grand juries to be abused, especially in high-profile cases as in this one. So now we've gone from talking very abstractly to talking in more specifics about exactly what is going on specific to JonBenét Ramsey. For his part, Mr. Ritter said, I don't think Alex Hunter would go to the grand jury for political cover. That's just not how Alex Hunter operates, said Denver District Attorney Bill Ritter. Well, you work on the man's team. That's fair. You can say that. The reason you go to the grand jury is because as a DA, you don't have the ability in the state of Colorado to compel testimony or to compel the production of documents. But then the article speculates, but no matter what the grand jury decides, its probe could help vindicate the impugned, I think that is, reputations of many other members of the Boulder Police and District Attorney's Office. So basically, we all get off free. We all go scot-free. Can't say nothing. Not only can you not say anything to me, you can't say nothing to anybody else. Somebody with a clear understanding of this had time to break it down and see how we can flip it. Because I understand what you're trying to tell me. But still, you use it that way. The article was misleading in that it stated that the new grand jury statute designed by Mr. Ritter and Senator Perlmutter to protect and exonerate people and vindicate the reputations of public servants was effective and therefore available for use by a Boulder grand jury on October 1 of 97. It also inaccurately described what allegations the statute deemed of public interest for the purpose of assisting them in the Ramsey investigation. The Boulder Police Department in July of 1997 accepted the pro bono legal services of Daniel S. Hoffman with the firm of McKenna and Cuneo, Robert N. Miller with the firm of LeBeouf, Lamb, Green, and McCrae, and Richard N. Bauer with the firm of Sherman and Howard, all prominent Denver attorneys. Responding to our public information request, the Boulder City Attorney's Office supplied us with copies of the final agreement between the city and those attorneys dated July 30th, 1997, and an earlier draft of that agreement dated July 28th of 1997. In the draft, these attorneys jointly made the following disclosures to the city. As we indicated to you, our respective firms have or had certain relationships that we feel obligated to disclose to you. Specifically, number one, Sherman and Howard, LLC, S&H, represents Lockheed Martin in various matters. Lockheed Martin currently owns Access Graphics, the company that employs the father of the deceased. In addition, in 1994, S&H represented Access Graphics in a lawsuit brought by a terminated employee. Okay. Number two, Mr. Hoffman is outside counsel for Lockheed Martin in a number of the litigations, one of which is currently pending. It is reasonable to assume that during our representation of you, Mr. Hoffman may be retained by Lockheed Martin. Additionally, Mr. Haddon represents Mr. Hoffman personally in a case against Mr. Hoffman. Additionally, Mr. Haddon represents Mr. Hoffman personally in a case against Mr. Hoffman, his former law firm, and a number of Mr. Hoffman's former partners at the firm. That's kind of confusing. Number three, Robert Miller is currently co-counsel with Mr. Haddon on a litigation in which they obtained a significant verdict for their client and which will proceed on appeal. John Ramsey was the president and chief executive officer of Access Graphics, a subsidiary of Lockheed Martin Corporation. In the fall of 1997, Access Graphics was sold by Lockheed Martin to GE Capital in a complicated transaction reported in the news media to be valued at $2.8 billion. The value attributed to Access Graphics was likely in excess of $200 million. Prior to the sale, John Ramsey left Access Graphics under adverse circumstances after attempting to purchase Access Graphics from Lockheed Martin. The value attributed to Access Graphics was likely in excess of $200 million. It should have been $1 billion or more. Prior to the sale, before the sale, John Ramsey left Access Graphics under adverse circumstances after attempting to purchase Access Graphics from Lockheed Martin. So you saying he tried to buy it back? Mr. Hoffman was identified in April 18th of 1997 issue of Colorado Journal to be the lead attorney for Lockheed Martin in an age discrimination case, which days before had resulted in a $7.6 million settlement. The Mr. Haddon referred to in the disclosures is Harold Haddon, the criminal defense attorney currently representing John Ramsey. The final agreement that was executed by the city and these three attorneys did not contain these disclosures. According to Mr. Bayer, they were deleted at the request of city attorney. The city attorney has recently indicated to us that he has no knowledge of the role these attorneys have played in the investigation. On March 10th of 1998, the Boulder Daily Camera reported that the DA hints Ramsey case headed for grand jury. 2 days later, the Boulder police made their request for a grand jury on the advice of these attorneys and transferred the case to the district attorney. On April 22nd of 1998, the Boulder grand jury was convened. It is certain that Boulder County District Attorney Alex Hunter, the metro area district attorneys advising Mr. Hunter, the current leadership of the Boulder Police Department, the three attorneys advising the Boulder Police Department, and the Ramsey defense attorneys have known since HB 97-1009 was signed by Governor Romer on April 8th of 1997 that to take advantage of the new statute, it would be necessary to delay a grand jury investigation of the Ramsey case until April of 1998. In retrospect, it is clear that the case was delayed for that purpose. It is hard to imagine that Governor Romer and members of the Office of the Attorney General and the Colorado Judiciary Department have not also long known this. The Boulder County District Attorney and members of his office have delayed the investigation of the death of JonBenét Ramsey in order to take advantage of a statute which will, if an indictment is not returned, enable them to persuade a grand jury to issue a report telling the public that the case was delayed and that an indictment was not returned as a result of police misconduct and the non-cooperation of witnesses. It will also enable him to publicly exonerate anyone alleged to have murdered JonBenét Ramsey if he wishes such a report to be made, and of course he does, since it would contain precisely what he has been saying throughout the investigation. He must first cause the grand jury to not return an indictment. But we know he did, in fact, and this is before the case, before we even got to the end. If you mistake his intention, my friend. Priscilla, you mistake. you mistake what he wants to do. Oh, Fleet. You guys misunderstood the game. No. We don't want a report to be made because then everybody would know everything in the transcript and they would know everything about the case. I don't want them to know all of that. And I don't want people to be exonerated publicly. Everybody has to remain under the umbrella of suspicion. Therefore, you have to return an indictment. So therefore, we can just close all this up and it'd be done with. This then is how politics will have been allowed finally to trump justice. So we see. Somebody needs to ask in what you call it, just to have it on record, Somebody needs to ask John Ramsey about this. Somebody needs to ask John Andrew about this. We already know what the answer is going to be, but we just need to ask, just to have it on record. Delaying this case in this manner simply to serve the selfish interest of a relatively small number of public servants and wealthy and powerful people has destroyed the case's infrastructure, which consists of the confidence and trust of witnesses and the public in the criminal justice system and the hard work done in good faith by police detectives. That he has allowed this destruction is compelling evidence that Alex Hunter and those advising him have no intention of seeking an indictment from a grand jury. By their actions, these people have demonstrated cynical and callous disregard for the people of Colorado, the criminal justice system, and the well-being and safety of the Boulder community and its citizens. What distinguishes the investigation of JonBenét's death from all others, and what has so seriously handicapped the investigation, is the extraordinary number of people that it has affected and influenced. The people of Colorado wish to see justice for JonBenét. They must not accept the conclusion to the case now being offered by the Boulder County District Attorney and Governor Romer. We will not. Priscilla and Fleet go on to say, after further assessing public opinion and reviewing the contents of this letter and that of Mr. Thomas, we hope it will occur to Governor Romer that evidence in this case must be reviewed by those who have no interest in seeking anything other than justice for JonBenét. This man is begging for justice for JonBenét, for justice for John's daughter. I got a daughter, man. I know. So this is coming from a concerned parent who has spent time with JonBenét, who has watched JonBenét, who JonBenét has spent the night at his house. This man is begging for justice for JonBenét, and he's going in. This man is taking out of his time. If nothing else, if you think Fleet and Priscilla White are trash, these people have taken out of their time to write this long letter, and they have gone and researched. They have no doubt worked with an attorney to compile this evidence to kind of state and be meticulous after they have read Steve Thomas's and heard Steve Thomas's perspective on this. They have gone and said, we support and we agree. This is where we're coming from, and let's talk about it a little bit more. After further assessing the opinion, we hope it will occur to the governor that we're seeking justice for JonBenét. Any further involvement of the Boulder County District Attorney, his prosecutors, or anyone else responsible for the delay of this case is totally unacceptable. He's trying to push and say, look, we need to get independent investigation. We need to get independent prosecutors in on this case for somebody that is not even my daughter. But I've been close to her, but I know her. I've watched her. She's come over my house, but she's not even my daughter. The people of Colorado must demand that Governor Romer resist. This man is demanding. He is going to the governor and he's fighting with the governor. The people of Colorado must demand that Governor Romer resist the advice of interested parties, including the district attorneys advising Alex Hunter, and immediately order the attorney general to take over the investigation and any future prosecution. He must then excuse himself from any further involvement. He is simply too close to people whose lives and careers may hinge on what becomes of the case. Taking this action will be difficult for both Governor Romer and Attorney General Gail Norton, who are serving the last months of their terms and are term limited from seeking re-election. They must nevertheless set politics and personal considerations aside and conscientiously deal with this problem now. It is unacceptable for them to further erode public confidence by passing that responsibility to their successors. The people of Colorado are entitled to be frustrated and angry with those public officials and other persons who have brought this case to its current status. We must be mindful, however, of the first cause of the investigation's failure, the refusal of John and Patsy Ramsey to cooperate fully and genuinely with those officially charged with the responsibility of investigating the death of their daughter, JonBenét. The key point here, fully and genuinely. You can tell me anything you want. You can make up anything that you want, but if you're not cooperating fully and genuinely, then what does it mean? I think, and this is, signed Fleet Russell White Jr., Priscilla Brown White, August 17th of 1998, Boulder, Colorado. I think I've said all I need to say. That's the video. Take care of yourselves. Hope you're having a great week. To the next video, like, share, subscribe. Continue to engage in the comments. Let me know your thoughts. I know you're going to do it, and I appreciate it. Much love to everybody giving their opinions and stuff like that. And to the next video, take it easy.